and I have to press the button to continue. There we go. And both funding of religion and government activity that appears to promote religion. And on the free exercise clause, what I think has happened, to borrow Justice Kagan's phrase, is the weaponizing of the First Amendment. What's happened is that the free exercise clause more and more is used in a way that the Supreme Court virtually unanimously in the 1980s said was not proper, to use it as a sword to harm other people's rights, whether it's LGBT Americans, people seeking abortions, or whatever the case may be. Those trends, I fear, are continuing, have continued this term, will continue this term and next term. And I fear for the future of religious liberty. I hope those of you in the audience will learn more about it and the roots of religious liberty and the importance of both these pillars to protect it.
Thank you, Elliot. Thank you very much. So Noel spoke about changes in culture, and Elliot spoke about changes in composition of the court. Let me ask Noel this, and then maybe Elliot can react. Changes in culture, but you know, the same kind of thing was being said, for example, after Brown versus Board of Education, where much of the country, based upon supposed biblical mandates, didn't want the races mixed. They certainly didn't want interracial marriage. They certainly didn't want women's rights. So, you know, we oftentimes think of religion, well, some of us, as a benign force, but some of the times it has been the most regressive, right, most reactionary force. And perhaps that continues today with regard to women's rights, and also with regard to gay rights. So isn't it always about a change in culture, and then we have religions that are objecting to it?
Oh, sure. You always have changes in culture, and then you sometimes have religious objections to change in culture. And look, the beauty of democracy with a First Amendment free exercise component is that we are at liberty to debate with one another to change our fundamental laws. The free exercise clause comes in, and the establishment clause as well, when you have pockets of individuals who object to those changes in laws. And then you have the conflict when you're asking them to do something that their religious beliefs tell them not to do. So I don't think it's meant to put brakes on fundamental changes in laws. The purpose of the free exercise clause is to allow individuals to, essentially, sit out from those changes if they want, within narrowly circumscribed spheres. You can't do anything you want under the free exercise clause, but it does provide a measure of protection to those who aren't willing to change their views along with the dominant cultural theme. And that's what we've seen in cases, throughout history, when you had, for example, the Amish that didn't want to participate in the Social Security system or the tax system, the Seventh-day Adventists who disagreed with the labor laws that were in place at the time, the worker who didn't want to, who was okay helping build sheet metal, but not sheet metal if it was going to be bent to use for missiles. All of these individuals had disagreements with the direction that the culture was moving on one issue or another. And then the question is, what measure of protection does the free exercise clause give to somebody to essentially absent themselves from those changes?
Okay. Now, Elliot, you want to respond to that? And in particular, because Noel is saying that the free exercise clause gives some kind of immunity in some cases. Although when I read the First Amendment, it says no law. It doesn't say except when Noel likes it or Scalia likes it or Elliot likes it, right? And probably no law is far too strict for you, Elliot, right? No law prohibiting free exercise of religion. What about that?
Well, the Supreme Court never interpreted it that way. So much for textualism, I guess. But I largely agree with what Noel said. I think one of the differences, as I mentioned in my opening remarks, though, is that what we've seen in recent years are efforts to really transform the shield of religious liberty into a sword, to go after other people's rights, whether it's LGBT Americans, whether it's women who want to take advantage of the law that gives them the ability to get reproductive care at work, and then all of a sudden, because a religious employer objects to that, they don't have that right anymore, which is what happened in the Hobby Lobby case. So that religion is sometimes being used improperly, in my view, as a sword and not a shield.
Okay, Elliot, let me ask you about this, because after the decision in, I'm not going to refer to it as employment division, blah, 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 you know, Oregon v. Smith, after that decision, in that decision, the ACLU and other liberal groups were arguing for strict scrutiny, right? I mean, it was an indigenous group, so, you know, darn well. I mean, Noel said a fringe group, but what he meant was it's not a dominant religion, not a dominant religion. So, of course, the liberals were going to be on the side, right, and arguing for strict scrutiny. So Oregon v. Smith comes along, and now any generally applicable law, if it's otherwise valid, defeats free exercise. Then the House of Representatives unanimously, right? And the Senate, except for 3 votes, I don't know who those bigots were. I don't know. But so the ACLU together with the conservative, it was like everybody wanted to get rid of Oregon v. Smith, right? I want to know what the heck happened to the liberals, because all of a sudden the liberals now just love Oregon v. Smith. They don't want to protect free exercise of religion under the strict scrutiny clause. In fact, one of the debates I've had recently with members of a few CLUs is that they don't want strict scrutiny for free exercise of religion. My understanding, it's the only damn fundamental right they don't want strict scrutiny for. So what happened with the alliance between political cultural liberals and political and cultural conservatives who all hated what was done in Oregon v. Smith, and now the liberals just seem to love it?
Well, I may have a somewhat different perspective on that. I was one of those people back in the day that was working very hard on RFRA. I remember standing right in between Orrin Hatch and Ted Kennedy at one of the signing ceremonies. And I think the feeling was that what we really wanted to do was to restore the compelling state interest test as had it been interpreted by the Supreme Court in previous constitutional cases. And that's an important qualification. Everybody agreed on that. The language was as close to that as we could make it. And I think people were on board as long as that's what was happening. But a couple of things happened. One of the most important one of which was that the Supreme Court in particular, as reflected in the Hobby Lobby case and a number of others, didn't want to interpret it that way. Instead, had a stricter version, a much stricter version of strict scrutiny that elevated the religious liberty interest over the other interests that are supposed to be competing, even under the compelling interest test. And I think that's a large part of what happened to change this, particularly since, as it turned out, the cases where religion clearly prevailed under the court's new RFRA test over other interests tended to be interests where people who wanted reproductive freedom, LGBT individuals, others in the more liberal camp were being hurt by, in my view, Supreme Court doctrine that never would have happened under the original interpretation of the compelling state interest test in the 70s and 80s.
No, with regard to RFRA too, I mean, it was my understanding that Congress explicitly wanted to return to Sherbert versus Verna and Wisconsin v. Yoder. And in fact, Wisconsin versus Yoder, I mean, Chief Justice Berger made it clear only interests of the highest order, not otherwise served. I mean, that's the strict scrutiny test. So do you have a different view of what was intended by RFRA?
Not fundamentally. I mean, I think was basically intended to re-adopt the strict scrutiny standard that applied before, but I don't think the Supreme Court has fundamentally changed that. standard. Hobby Lobby, the real issue in Hobby Lobby was less strict scrutiny and more, did the law impose a substantial burden on religious beliefs? In other words, when you made a religious for-profit company fund certain abortifacients and contraceptives in their health plans when their religion told them they shouldn't do that, was that imposing a substantial burden on their free exercise of religion? And if it was, then you get to the strict scrutiny analysis. And I think that the court's jurisprudence on substantial burden has been fairly consistent. What they have said is that it's not up to the court to decide what somebody's religious views are. It's up to religious adherents to say what their views are, even if those views are seemingly irrational to the rational world. And once they have articulated a sincere belief that this is in fact my religious view, no matter how bizarre it might seem, the substantial burden then test asks, are you being required to do something that your sincere religious beliefs tell you not to do? That, I think, is a pretty consistent line in the Supreme Court's case law dating well before Yoder and Sherbert. And so I don't think that there's been a change there. On the strict scrutiny side, again, I think that they haven't had as many cases that apply strict scrutiny. I also don't think it's all that controversial when they get to the strict scrutiny analysis. Usually the fight is over whether you get to strict scrutiny in the first place, not how strict scrutiny applies.
Yeah, if I can add one small thing, I actually agree with what Noel just said. I kind of group together within the strict scrutiny umbrella both the substantial burden analysis and the analysis of other alternatives. And I highly recommend Justice Ginsburg's dissent in Hobby Lobby that explained much better than I did how the current court has substantially changed the substantial burden test in a way that has harmed people like the women in the Hobby Lobby case.
I think I remember Justice Ginsburg's argument by and large was that doing away with the contraceptive mandate or allowing exceptions to it kind of undermined the entire purpose of the Affordable Care Act. But as I recall Justice Alito's majority opinion in the Hobby Lobby case, didn't he focus quite a bit on the fact that we know darn well that there are less drastic alternatives because there are already exemptions built into Obamacare, right? And so we know darn well that you can grant exemptions. Why are you not granting one for a First Amendment right?
Yeah,
is that right?
I mean, it's an interesting opinion. If you read it, there's a square holding on substantial burden, the issue that Elliot and I were just talking about. When it gets to the compelling interest and narrow tailoring parts of the inquiry, he has a lot of language about how, well, surely this is a compelling, surely, or he questions whether there's a compelling governmental interest, but then ultimately says, don't really have to decide that. Then he gets to narrow tailoring and says exactly what you're suggesting, that clearly this is not narrowly tailored because there are lots of alternatives, including the government can pay for and provide the contraceptive coverage itself. But at the end of the day, and I think this may have been the price of getting 5 votes, he said, we don't ultimately have to decide that at all, because here we already have in the regulation itself what was called an accommodation. The accommodation essentially said to religious organizations, if you sign this form objecting to contraceptive coverage, you no longer have to include it in your plan, but your health insurer will then have an obligation to provide that coverage to your employees for free. In Hobby Lobby, the private employers weren't objecting to that provision. That came in a later case, the Zubik case. So what Alito said is, because we have this one already baked into the regulation itself, you could have just applied that same accommodation to the for-profit religious employer. And so you clearly have a less restrictive alternative. So we had a lot of very good rhetoric, but ultimately that good rhetoric wasn't part of the holding of the case.
And Elliot, along those same lines, do you think the court has taken that particular prong, the least restrictive alternatives? Do you allow accommodations at all? Do you think they've taken that and run with it a bit too far? So, for example, in the Philadelphia case, right, the Fulton case with the Catholic services, placing or refusing to place foster children with same-sex couples, the court says, well, you know, apparently Philadelphia says that there can be an exemption made. And even if they've never made an exemption, because they've simply said in the law that there can be an exemption, why the heck aren't you giving an exemption for religious free exercise? So does it seem to you like the court is just taking that second prong of the strict scrutiny test and taking it a heck of a lot further than the strict scrutiny test usually requires?
I think that's often true. And frankly, what the strict scrutiny test really means depends a lot on who's doing the interpreting and what kind of case it is. There's no question that what you're describing has happened a lot in religious liberty cases, with the notion of, and we now move to more contemporary cases, excuse me, the notion of religious liberty being used in a way that is not used and not accorded to other fundamental rights.
And when you talk about other fundamental rights, what are you talking about?
Well, we think, for example, about rights against discrimination in various types. Now, again, it often happens before you get to the compelling interest part, but we've seen that often we've seen a kind of a weakened test when it comes to voting rights and other cases in more recent years.
Right. So, for example, like in the bake shop case, the court really didn't want to tackle the darn issue with whether or not a religious objector should have to create a cake celebrating a same-sex marriage. So the court said that the state of Colorado was hostile and didn't give a fair hearing to the baker. So they didn't really have to confront, right, a direct conflict between religious free exercise and non-discrimination against same-sex couples. So Noel, I want to ask you that quite pointedly. We have a slew of cases right now coming up. They're percolating in state courts and lower federal courts. And many of them have to do with religious objections to serving same-sex couples, right? And it seems to me we had some of the same darn thing with regard to religious objections over interracial marriage. So
Yeah.
Is it different today, or is the same thing, and who should win?
So I think it's really, I argued the Masterpiece Cake Shop case. And
Did you argue for that result?
I argued for that result, but the reasoning that the court adopted wasn't something that anybody had really argued for. And if you well, I shouldn't say that. The baker himself, I think they did have that argument, but that wasn't part of the United States position in that case. What you really ought to focus on are the dissents by Justice Gorsuch on the one hand and Kagan on the other, because it's a big argument over what exactly Justice Kennedy's majority opinion meant. And I personally, probably no surprise, found Justice Gorsuch's opinion the most compelling. What he essentially articulates is something that he's now been able to develop through more recent free exercise jurisprudence. It's essentially most favored nation status for religious organizations. So the idea is that if you're going to treat any group at a certain level of favorability, you've got to give religious organizations the same favorable treatment. So in the Masterpiece Cake Shop case, what he focused on was the fact that under Colorado law, if, for example, somebody came in and asked for a cake that was offensive to the baker on other grounds besides sexual orientation, maybe
we love Hitler.
Yeah, we love Hitler, or we are against same-sex marriage and make an anti-same-sex marriage cake. It's clear that Colorado law would not have forced the baker to bake that kind of cake. And so what Justice Gorsuch was saying, well, I mean, under that kind of equal treatment principle, you can say that everybody has to bake any cake for anybody that walks in the door. That's a general principle where you're treating everyone the same. But what you can't do is construct a set of rules that treat the religious baker worse than other kinds of bakers. You then take that principle into a lot of the Smith cases, because Masterpiece Cake Shop wasn't really a Smith case. And you see the court developing that same basic most favored nation status principle. And I think that's what they were getting at in the Fulton case. That's what they were getting at in a lot of the COVID cases, where they look to see how other non-religious organizations are being treated. And if they're getting more favorable treatment than religious organizations, then in the court's view, you've got a real problem, because you got to give the religious organizations that same favorable treatment. I also happen to think that that's one of the ways where, without formally overturning the Smith decision, you can bring the results in Smith, in post-Smith cases, closer in line to the results that you would have if Smith were in fact formally overruled.
Yeah, well, of course, the court, I mean, apparently they can't get 5 votes to overrule the Smith case, so they try all kinds of alternative ways to reach the result they would have reached with strict scrutiny. But with regard to the Gorsuch opinion, I mean, I really have to take a different side on that one. I mean, there were certain things, obviously, that his clerk must have gotten right in writing that opinion, but there were some things in there that were absolutely ridiculous. So, for example, the baker would not have baked a same-sex cake for a heterosexual couple. Well, I mean, what in the Lord's name? That's like the argument, saying, well, we're not discriminating against Black people in the anti-miscegenation laws because white people have to marry within their own race as well. I mean, I don't know, you may like Gorsuch. I'm just so totally underwhelmed by all of his
I neither like nor dislike the Supreme Court justices, or I should put it another way, I like them all equally. Every time I'm up there, I don't much care where my 5 is coming from when I'm standing up at that
See, that's legal realism. Justices, right? Yeah, you got.
But I guess I should say that's not how I took Gorsuch's opinion, the way you put it, the way I.
But he actually says that. No, you may not want to take it that way. He says
Maybe I just don't know. I haven't read it in some years now.
But you and I are on the same side in the Catholic Diocese case.
But I think that the core of it is moving towards this most favored nation principle that's been articulated in a lot of different free exercise areas now.
Elliot, you want to take on Gorsuch, Noel, me? What do you want to do?
Well, I agree with much of what Noel and you have just said. I fully agree that the court is moving towards this most favored nation clause and interpretation. The problem with it is most favored as compared to what? Let me give you another example. The Supreme Court flipped sides when Justice Barrett replaced Justice Ginsburg in cases relating to exemptions from COVID restrictions granted to religious institutions as opposed to others. Now, for example, in one of the more recent cases, the issue was how many people, unrelated people, could gather together in a home for worship services, and the majority, including Justice Gorsuch, said, we're not buying this because you let more than 3 families get together in a shop when they want to go shopping, or in a movie theater or something like that. Well, the dissent, I think, had the right. And that was their version of the most favored nation clause. You got to give us the same treatment as any other institution at all. But the problem is you can't really compare people talking or praying or conversing with each other in a home with being in a large store or something like that. And that was what the dissent pointed out. The fact, including, I should say, Justice Roberts, who didn't much like the decision. You can't give religion the treatment of any other institution, no matter what it is, no matter how different it is, in my view. What you need to do is be comparable. So what the dissent said there was, look, this same rule, no more than 3 families unrelated getting together in homes, applies to secular gatherings in homes for political discussion or whatever. So therefore, it's not discriminatory. But by changing the denominator by changing what nations are considered favored or not to include shops where people go in and out for a short period of time and things like that. In my view, the majority's version of the most favored nation clause elevates religion in a very dangerous way.
Thank you. Elliot, I want to move the discussion a little bit away from that, although sticking with the bake shop case, because I found Justice Thomas's opinion quite interesting and somewhat persuasive. And he was saying that the baker in creating these cakes was involved in an expressive activity. It's a work of art and it's expression, and we do protect free expression. Having said that, I always just love it when these textual originalists, take the word speech and suddenly it means corporations giving money to political committees, or it means baking a cake. But not being a textualist myself, I found his argument very, very persuasive. What do you think about that? In other words, supporting free exercise of religion oftentimes as an expressive activity. What do you take of that?
Well, I think we're going to find out fairly soon, because the Supreme Court just took a case that was literally designed to test that very proposition. I think it's the Beckett Fund, I don't remember for sure which organization it is, brought a declaratory judgment in Colorado, which is the same state where the cake shop case was from, on behalf of a woman who says she wants to open, she hasn't yet, she wants to open a business that does wedding videos for people. And she wants to A, not serve people who want same-sex weddings, and B, say that right on our websites. We won't serve people who want same-sex weddings, period, end of quote. And although there was a free exercise claim raised there, the issue on which the court took cert, again, in a case that isn't really a real one yet, as the majority pointed out in the decision below, but they took this case focusing on the free expression issue and whether, the way they put it, hopefully the case won't come out this way, whether someone can be compelled to exercise a certain kind of expression. My concern, put quite simply, is that if this woman can do that with her website with respect to same-sex weddings, why can't you do it with your website with respect to interracial weddings?
Yeah. Noel, you want to respond to that? What do you think about this argument that this is free expression?
Well, look, when I was the Solicitor General, that was the position that we actually wrote a brief on, and we said that it was free expression. And I think it's a difficult issue, but if you're going to conclude that art is protected by the First Amendment, so is Picasso, is Rembrandt protected by the First Amendment, these individuals, this isn't a sheet cake that you're making. The cakes that are involved in Masterpiece Cake Shop, and I think the photographer, this is a photographer in the new case. I think photography is something that's
Videographer.
What is it?
Videographer.
Videography. Okay, something. So film, something that's more traditionally understood as art and therefore speech. And so the question is, what makes this? They may have a different medium, but what makes it any less speech? The tough counter hypothetical that I pointed to when we were taking this position for the United States was that there are some jurisdictions where their anti-discrimination laws don't simply prohibit discrimination based on race, sex, sexual orientation, but also, including, for example, Washington, D.C., prohibit discrimination based on political ideology or political party. So could, the Republican Party then, say you've got some artist or singer or entertainer that holds themselves out for hire, the Republican Party says, we want you to come and entertain at our political gathering and we're willing to pay your standard fee. And the person says, golly, I can't, I'm against everything you stand for. There's absolutely no way I'm going to show up and entertain, your horrendous crowd. Under the principle that was articulated by the state of Colorado and Masterpiece Cake Shop, and I assume that's going to be articulated in this new case. In Washington, DC, that person actually does have to show up to the Republican National Committee and conduct entertainment for an organization that they otherwise oppose, because presumably that entertainment or artistic expression isn't protected speech.
Yeah. So
I do think there's an important difference, if I can interject. I don't think that there will be or is a compelling interest by the government in protecting against discrimination based on political point of view in that context. I do think, though, there is strongly a compelling interest in protecting against discrimination based on race or based on LGBTQ status.
Well, that's actually the question and the one I was going to follow up with, because whether we phrase these issues in terms of free exercise of religion or freedom of expression, it begs the question whether or not the government, whether it's Colorado or any other state, whether they do have an overriding interest in prohibiting discrimination, reducing discrimination. So, and of course, getting back to Chief Justice Berger, who, as I told you, he hired me and then he immediately resigned. He was so embarrassed. But in his case, in the Bob Jones case, right? Bob Jones, for religious reasons, didn't want any interracial dating. In fact, they prohibited blacks and whites from being in the same student organization, but they still wanted the benefits of the charitable organization under the tax code. And Chief Justice Berger, no particular liberal he said, no, I mean, we fought a civil war over this stuff. We have to, it is our mission, and it must be our mission to eradicate as much as we can racial discrimination, even if that means overriding free exercise of religion. So what about eradicating discrimination against LGBTQ persons, same-sex married couples? Does that meet the same standard or a similar standard? No?
Well, I think that it meets the same compelling interest. I think the government, it's not hard for the government to establish their compelling governmental interest in all of these cases. But these tests tend to be balancing tests.
No.
And when it comes to cases like Masterpiece Cake Shop or this other case, part of the analysis has to be, are you actually depriving same-sex couples of the services that they're trying to obtain? And the fact of the matter is that the vast majority of videographers, the vast majority of bakers, for economic and other reasons, are perfectly happy to bake the cakes and to perform the videography services that are being sought. And so the question is, I think this kind of colors a lot of the cases. The question is, why are you going after this one baker in Denver or this one videographer? And I think there's a real sense that you're going after this person, not because you're actually being deprived of the service that you need and can't otherwise get, but because there's an effort to essentially say, your dissenting viewpoint can't be tolerated. And so we are going to use the force of the law to stamp out your dissenting viewpoint. And I think that's the background of a lot of these cases.
But,
Can I add something on that? Because it's one of the reasons this 303 creative case is so dangerous. No one has asked this videographer to make a video of a same-sex wedding. She hasn't even gone into business yet, but she wants to claim an affirmative right, not only to refuse if such a case came along, but to put it openly on their website. We won't do same-sex weddings. I don't see any difference between that and saying we won't do interracial weddings. And it's I think that is what is very disturbing.
Yeah, look, if I understand the facts of that case, I think it's a little more nuanced now. What she wants to do is explain her position. She wants to explain her religious beliefs and why her religious beliefs prevent her from performing certain types of services. So I don't think it's quite as simple as need not apply.
But we shouldn't quibble about the facts, but there would be a pretty clear disclaimer with an additional explanation that would say no same-sex weddings here, just like someone else could say no interracial weddings here. You know, it wasn't that long ago in the 50s and 60s when merchants, primarily in the South, claimed they had sincere religious beliefs against serving African Americans and claimed that view as the reason for not complying with civil rights laws. That was squarely rejected by the courts. And I fear it may be coming back again.
Well, I would like to quibble with Noel because remember, we're still working on the same page. And then, as you know, in Bob Jones University case, I mean, Chief Justice Berger didn't say, well, why the hell don't these black students go somewhere else? He didn't say that, right? I mean, there was another alternative. And, you know, for example, my father-in-law, when he was taking my wife and the other kids around the South, you know, they had this green book, you know, because they couldn't stay at certain hotels. I don't ever remember the Supreme Court suggesting in their wildest imagination, well, you know, yeah, it might be racial discrimination, but you could just go somewhere else. So I don't know how strong that argument is.
Well, I think it plays into the balance because you have to remember all of these horrendous racial discrimination laws were part of a Jim Crow construction in the South that were actually meant to deprive Blacks of exercising fundamental rights of going somewhere to stay at a hotel or at a certain lunch counter. So it was part of an entire legal construct that the country that at the national level was trying to break down. I think there's a world of difference between that and what we have today, where by and large, the dominant culture is against withholding services on the basis of sexual orientation or these other factors. And you really only have a relatively small number of people that are trying to engage in, you know, in these cases, what they believe to be expressive activity in a way that's consistent with their religion.
Right, but even
so I
if
think it's quite different.
But even if it's expressive activities, I mean, do we say, well, there's only a small percentage of the country that wants to discriminate on the basis of race or on the basis of LGBTQ? So yeah, we should allow it.
I think that's baked into the strict scrutiny analysis because it ultimately boils down to a balancing test. That's what these types of tests are. And so I do think it is baked in, you know, how big of a problem is it? Are there other ways to solve it? And can we resolve the issues in these other ways?
Okay, well, I haven't been too nice to you, Noel, so I'll throw you a bone. The free exercise clause again says no law. So why are we even balancing that? I don't understand. Why are we even balancing that? I take you to be a textualist.
You know, as Elliot put it, there's a lot of water under that bridge. The other question is why does it says Congress shall make no law.
I know, of course.
So
Nothing about it.
Why on earth are we applying it all to the states through the 14th Amendment? But again, there's a lot of water under the bridge on that. So, you know,
But maybe they were wrong every time.
Maybe they were.
Maybe they were wrong.
So it shouldn't apply to executive action, for example. I think that the sense is that at the end of the day, at least if you look at it at the federal level, there are only things that are done under the law. Either it's a congressional law that does it explicitly, or it's a regulation or an executive action that is implementing a law, because the executive branch doesn't itself have the authority to make laws. Only Congress can make laws. And then in terms of the states, there was I'm not an expert on incorporation, but there's a general belief that the 14th Amendment was meant to take the Bill of Rights and apply them to the states. And so you naturally have to then do some kind of non-textual adjustment to make the basic principles apply to the states through the due process clause.
Well, no, you probably don't know it, but Benjamin Cardoza, I think he taught it. Was he an adjunct here? Didn't he teach a course here? He taught a course, it was Bolko versus Connecticut, where he said free exercise of religion, freedom of conscience was implicit in the concept of ordered liberty. What do you think of that? He was right here, just like you and I. Well, this was the library when he was.
Well, you know, I mean, at the time of the founding, when they were debating whether or not to have the Bill of Rights, there were many who were opposed to having a Bill of Rights, and their basic defense was that you don't need a Bill of Rights. The federal government has only very limited and specific power. How on earth do they have the power to infringe on the free exercise of religion? All they can do is, regulate commerce and raise an army or a navy. But the others wanted a belt and suspenders approach. And so they adopted the Bill of Rights because they weren't sure that they could trust this new government to stay within the bounds of the enumerated powers of the Constitution.
And they were also,
turned out to be right.
And they were also worried, of course, that later on, some people would say, well, it's not there, so people don't have those rights, right? Hamilton, Jay, Madison, they said, well, we better not have it. It's dangerous to start listing some. Yeah, but anyway, let me get back to you, Elliot, because I want to ask you about this balancing test again, because you apparently seem to want to, and of course I'm overstating it just to have fun. You seem to be overstating the extent to which there's water under the bridge with the First Amendment and no law. But it does say no law. How much do we disregard that? Do we disregard the prohibition against any law, right, prohibiting free exercise of religion for the kinds of things we happen to think are pretty good today? And so we outweigh religious free exercise with those? Is that what we do? Because that is what we're doing, right?
I think we do what has traditionally been done with interpretation of provisions of that one in the Constitution, which is look at the text, but also look at the history, the structure of the Constitution, the way it's been interpreted and all the rest, and figure out what makes sense. What is the way the text should be interpreted? Frankly, most textualists will admit that that's really what happens. Some pretend not to, but that is what happens. And it raises an important issue, I think, about constitutional interpretation that is not at all confined to the First Amendment. It applies up and down the Bill of Rights. And one of the important parts that we haven't mentioned is, of course, the 14th Amendment and the Equal Protection Clause, which, what does that mean? Well, you can look at the text, but you have to give it content in the context of specific facts and circumstances.
Well, of course, the Equal Protection Clause does not say except for women, which apparently it was interpreted to mean until 1971. It didn't say except for gays and lesbians, which apparently it said until, when was it? 2003, they finally came out of the caves on that one, Noel? Lawrence v. Texas. Right? Yeah, well, they made homosexual sodomy a fundamental right. Remember that one? That was your boss too. I mean, Lord. But anyway, I love you, no. But yeah, so I mean, it's been a long, long road. A long, long road, not only in actually taking free exercise of religion seriously, but also, as you point out, Elliot, equal protection, taking that seriously. We have not taken that seriously in the history of this country. I mean, it was almost 200 years before we finally said, hey, all those things we said about women, not being entitled to vote, not being entitled to go to law school, not being entitled to own property, we kept upholding all those laws. Well, maybe those laws were arbitrary. And you remember who wrote that opinion too? That damn conservative Justice Warren Burger again, Chief Justice Burger. Boy, the conservatives would hate him today. But in any event, should we open it up for, or do you want to make a,
No, that's whatever you want.
No, tell me why I'm crazy. Let's open it up for questions. I know some of you have questions. And I wish you were teaching my con law class because maybe they would believe me when I said some of these things that you've been saying. Yeah, you too, Elliot. Okay, so what are your questions out there? Oh, come on. We have two extraordinary, yeah, go ahead.
So I'm sure you guys are familiar with some of the cases the Satanic Temple has tried to bring on this. So, they have a habit of showing up when people are passing out Bibles and say, well, that's interesting. I'd like to pass out my Satanic Temple material. And all of a sudden people want to ban all the religious material. And there's that case coming up where they're saying part of our religious belief is that you should have access to an abortion, so you can't ban it for us. I'm curious where I'm skeptical of this working on any level, but I'm curious where you think that's going, where that fits into this.
Go ahead with
I'm not actually familiar with with the fact pattern. The first part of it, that satanic individuals should be able to distribute their satanic Bible, I absolutely agree that they should have a right to distribute that Bible. And if there is any law that prohibits them from doing it, then I think that that law would be unconstitutional. I haven't really thought so much about the other hypothetical. I'd want to give that one a little more thought before shooting off the cuff on it.
Yeah, it does require some thought, but it's not. This is not the first time it's been raised. As the Supreme Court gets, unfortunately, ever closer to overturning Roe versus Wade, there have been strong, serious arguments and law review articles, et cetera, suggesting that it might be possible for religious adherents who strongly believe that there is a religious principle that requires their ability to get an abortion, may be able to make an argument again like that against one of the strict anti-abortion laws that the court may now allow to take place. So so I fundamentally agree with Noel. I think the answer is unclear what the court will do. I don't think this court would recognize such a right after having overturned Roe versus Wade. But over the longer term, it's an interesting question, and it does recognize the importance of one thing that I think Noel and I agree on, of the importance of treating religions equally in terms of those sorts of arguments.
I suspect the answer to that other hypothetical would be in the application of, or at least one answer is the application of strict scrutiny. You would say that, if the government has say some satanic person said, my religious belief says not that I can have an abortion, but that I can actually kill somebody. Obviously, the government could prohibit that. They have a compelling interest in prohibiting you from killing somebody. And there's no less restrictive way of prohibiting you from killing somebody than prohibiting you from killing somebody. And I think that you basically just see the same analysis applied in the abortion context.
Now, I don't know what beliefs or exercises satanic cults have, but suppose
Neither do I.
But suppose there was some kind of a cult and they did believe in certain really torturous killing of goats, better or worse, because we know there are religions that do all kinds of things. So they believe in a certain kind of killing of goats, but of course there might be local laws requiring or prohibiting any kind of inhumane treatment. So on the one hand, we have local laws prohibiting inhumane treatment, and yet on the other hand, we have that problematic First Amendment. So what do we do with that? So no law prohibiting the free exercise of religion, and yet there is this local law that tells this cult, you're not allowed, and we'll say, well, you call it a cult when you don't want to say it's a religion. But then we have this law that says, even if you're a religion, you're not allowed to kill a goat this particular way. What do we do with that?
I mean, to me, it would probably be the same strict scrutiny type of analysis. If you want to prohibit the cruel treatment of animals, and there's not a less restrictive way of doing it than prohibiting cruel treatment of animals. So the question, a lot of these cases come down to not substantial burden, not compelling interest, but to narrow tailoring. And can the interest be achieved in an alternative way? In the cases that you and I have handled together, things like when the state requires a religious organization to cover contraception as part of their insurance plan, or cover abortion part of their insurance plan, there's almost always a pretty strong argument that the state can achieve its interests in other ways by, for example, paying itself for the contraceptive services or the abortion services. For these types of extreme hypotheticals, it's hard to think of a way that the state can achieve its interest in a different way other than simply banning the practice.
But for example, Judge McConnell actually did raise that sort of thing when he said, imagine a local law that is requiring a certain kind of humane slaughtering of animals. Would Jews be prohibited from their brand of kosher slaughtering of an animal? And
That was essentially the issue that the court addressed in the Church of Lukumi Babayali case. That was a case where you had local laws that were ostensibly aimed at humane treatment of animals, but really seemed to be aimed at prohibiting the practice of Santeria. And the way the court addressed it there was they did a very detailed analysis of laws and tried to figure out, is this really about the humane treatment of animals, or is this really about prohibiting the practice of Santeria? And what they concluded was that you essentially had a legal gerrymander where everything was allowed except for the practice of Santeria. And so it was pretty clear to the court that this wasn't an attempt at some neutral law to further the humane treatment of animals, but was really targeted at preventing the practice of this one religion.
Right, but there are laws about treating animals humanely that aren't targeting the Jews, right? Just like there are laws generally requiring anybody with evidence of crime to be able to be subpoenaed into the courtroom, but we make exceptions, right, for priests.
Well,
But
Justice,
suppose you get a state that will not make an exception for a priest.
so Justice Scalia was once asked after he issued the Smith decision, what if the state passed all consumption of alcohol, including sacramental consumption at Catholic masses? And his response was, well, that's why we have a Second Amendment.
Oh, Lord. Elliot, you want to say anything about this?
Well, I think this is one where we're all pretty much on the same wavelength. There have been cases on the kosher slaughtering methods, and the last time I looked anyway, courts had pretty much upheld that and had argued that in fact there is a religious reason for that poses the kind of interest that the government can't properly overturn, partly because of gerrymandering issue, but maybe even without intent. And that again gets back to the issue of Smith, because the difference with Smith is whether or not the government practice that has a substantial burden on religion is intended to do so, among other things, whether it just has that effect. And that was one of the problems we had with the Oregon versus Smith decision as written, trying to eliminate that distinction.
What do we do about those cases in the States? And there's countless cases in the States. And oftentimes they do involve LGBTQ persons. Although sometimes they're as ridiculously simple as, are the Amish allowed to use something other than that garish triangle when they are in their horse and buggy and they're moving very, very slowly? And then you have some states saying, we love Oregon v. Smith, and so the hell with the Amish. They got to have the triangle, even though it violates their religion. You get, so that's what Kentucky did. Then you had Wisconsin saying exactly the opposite. No, we are sticking with strict scrutiny. And then, of course, you got California. I mean, California's supposed to be liberal, and they said, no, we're the hell with strict scrutiny. We're basically applying Oregon v. Smith. And that was by and large because it had to do with the same-sex couple that wanted to rent an apartment. And the landlord said, I can't allow you to rent an apartment because, it's against my religion, same-sex intimacy. And so you have that, and then again, the New York rule, which is the worst of all, which is that when there is an abridgment of free exercise of religion, the religious objector has the burden, not the government. The religious objector has got the burden of showing that the law is unreasonable, right? And that by and large are the sort of cases that Noel and me silently are dealing with. So what do we do with cases like that? Is there another side to those cases other than the side that you and I are on?
You say with cases like that.
Well, because now we had the contraception case, and now we have the abortion insurance case. Yeah. Is there another argument? Is there another
Other than the
side?
one that, well, there surely is another side because we're appealing, we lost.
I mean, is there a legitimate? Is there, and some of you that had me for class know that the New York Court of Appeals, which you know I love, they didn't even think there was a constitutional question in the abortion insurance case. And then the Supreme Court summarily vacated what the New York courts had done. But let me ask you, Elliot, is there another side to these arguments? So should religious organizations be required to pay for abortion coverage or contraception coverage when that's against their religious beliefs? And even when, as in New York, there are exemptions. New York already has exemptions, right? So is there another argument?
There's always another argument. Take
sorry.
two lawyers, and there's always another argument.
Yeah.
But I think that as was discussed before, when there's a fundamental right to reproductive care, whether it's abortion or contraception, what I personally think is the right way to go, and it'll be interesting to see what happens in your case as it goes further, is there a way to accommodate the interests of those who want to get that care without infringing on the religious rights of people who object? Now, whether there is an infringement, how substantial the burden is, does it apply to for-profit as well as to not-for-profit groups? Those are all questions that have to come out in the wash, but I think it illustrates the importance of this kind of balancing test, looking at the fundamental interests involved, both the interest in religious liberty and the interests perhaps created by statute, at the moment protected by the Constitution, in reproductive rights.
So are you agreeing with the Supreme Court's recent cases where it says, if there's a possibility in the law of exemptions and accommodations, that you must give one when one is being sought on the basis of fundamental free exercise of religion?
Well, it depends in part on your definition of if in that context. And the important thing, as I suggested before, is who's the right comparator. You should compare a religious exercise or desire to do something with a non-religious exercise and treat them equally, but you don't have to have the court's version of most favored nation, where because people can walk in grocery stores with more than 3 families at a time, they can also have religious services at a home with more than 3 families at a time, even when COVID is a serious issue. You have to look at the context. It's hard, in my view, and I think Noel would agree with me on this, to set an absolute principle in almost any of these cases. You have to look at the context.
Want to respond to that?
Yeah, no, I mean, I don't disagree with what Elliot was saying. You know, my understanding of what I've been calling the most favored nation status principles, it's rough justice for strict scrutiny. So essentially what the court is leaning towards is, if you have a law and there is absolutely, you're not willing to brook any exception to that law, that's a pretty good indication that it's really, really important, and exceptions would undermine the application of the law. But once you start walking down the road to exceptions, I think the way I understand it, at least, is it's another way of saying you haven't satisfied strict scrutiny. So it's a way to overturn Smith maybe without actually overturning Smith.
But isn't there a most favored nation status, or shouldn't there be a most favored nation status for free exercise of religion?
Yeah, that's what I think the court's recent cases are.
So it's favored.
But again, it's a question of defining what that status is and where does it apply. In the case I was talking about, if secular activities, political meetings are allowed to happen in homes despite COVID with 3 or more unrelated families, then of course religion should be treated the same. But if you move to a totally different universe, which is what happened in California, and say, well, there can be 3 or more unrelated people who go into a grocery store, that doesn't justify giving a religious institution in a home that same treatment.
Is there another question up here? Yes, go ahead.
Sorry, two things. One, circling back a little bit, I'm no expert, but my understanding of the Satanists are, it's like a tongue-in-cheek. We're gonna take a liberal stance and frame it in religion so that we can fight this. So
It's a secular organization.
it's a secular organization. So that does raise questions of sincerely held beliefs. But anyways, I was wondering, I don't know if any of you were following the Canadian case with the minister that came out in front of her congregation as being an atheist and was fired and brought a suit of wrongful termination on the basis of religion. And I just thought, like, how would you think that would happen here? Or is it just a non-starter, like in America?
So fired from a religious organization?
She was a United Church reverend, and she came out in front of her congregation as being an atheist and was fired, and brought a suit that she was wrongfully terminated on the basis of religion.
That's a softball, no?
I mean, I can't imagine that suit would be successful here. I'd want to think through why it wouldn't be successful. But, you know, it's like a Catholic priest standing up before his congregation and announcing that he no longer believes in, you know, the Holy Trinity or transubstantiation or Catholic doctrine. You know, it makes me think of, you know, in a lot of the anti-discrimination laws, there's a bona fide qualification exception, meaning if sex, for example, is the bona fide qualification for a job, then you have to meet that qualification, and discriminating on the basis of sex doesn't violate the discrimination laws in that narrow context. It strikes me that a bona fide qualification of being a minister is that you actually have to believe in the thing that you're preaching.
And in fact, the court has expanded on that, right, in the ministerial exemption case.
At the very least, you can't affirmatively disavow the thing that you're.
It was such a weird case, like I was, what's going on in my country? I don't know if you're not following it beginning.
I didn't, but I do remember hearing news reports about it. I'm going to jump in. We have a question from the chat. And here's the question. When the court looks at questions of, I refuse to do this because it's against my religion, do they analyze whether an actual contention is supported by that religious texts? For example, as far as I know, the Bible doesn't say anything about divine punishment because you baked a cake for someone else's gay wedding, even though you may face divine punishment if you attend your own gay wedding.
Elliot, you want to take that?
I missed a little of it in due to the audio, but I think the court's made very clear that to claim that someone's religion is burdened, they don't need to point to a particular sacred text or something like that. But it is a matter of the individual's belief, and I think that's probably right. However, in the particular case that I didn't hear all of that was being discussed, there may well be a reason, independent of whether it's supported by religious text, why the argument of the religious adherent wouldn't necessarily prevail.
And just to expand on it, there is an element of the doctrine that says it has to be a sincerely held religious belief. So you can have an inquiry into the sincerity of the beliefs. You mentioned the Satanists who maybe were just doing it as a joke, that they would then probably fail at the gate if you could prove that it was just a joke. This wasn't a sincerely held religious belief. It's not a very hard standard for a religious adherent to meet the sincerity prong, because courts aren't going to dive in and try to figure out if your belief is logical. They're just going to try to figure out if you actually believe it. I'm not aware of any major case that has turned on the sincerity of the belief.
Well, there was that MasterCard case. There was the case where there was an inmate who was insisting that he should be allowed to make MasterCards, right? And they said, okay, that's not sincere at all.
Or the prisoners that are of the Church of Red Wine and Filet Mignon, where they claim their religious right to that diet.
And certainly in terms of logic, I mean, no court ought to be involved in determining whether or not a religious belief is logic. I mean, we Catholics would go wide on it too. You know.
But they
come on.
can engage in the inquiry of whether or not
Whether
you
it's
actually
sincere.
believe it,
Yeah,
whether you actually believe
believe it. That's right. Yeah, yeah, but you don't have to prove to any court that it makes sense that we believe that bread and wine are turning into the body and blood of Jesus Christ. No, you don't want to do that. Religions aren't based upon that kind of thing. But that doesn't mean anybody who claims a religious belief or a religious exercise just gets carte blanche on that. No, that's not the case at all. And not only that, the courts have never held, like Elliot was saying, the courts have never held that you have to prove to us that, you know, there's some source for your belief, like the Pope said this, or the Bible says this. No, if it's a sincere religious belief, that's the end of it. And, you know, you kind of get into this when you get the complaints, well, the baker didn't mind creating a cake for second marriages, people who have been divorced, and that's against his religion. Well, you know, in religion, you're allowed to pick and choose. You are allowed. That may go to how sincere your belief is, but you're allowed to pick and choose. You know, cafeteria Catholics. Here's one of them. You know, I mean, that's the way these things are. I'm entitled to free exercise of religion. Go ahead, Dean.
I do think that this issue is coming up around exemptions for vaccines, because you do see different organizations, including states or state-related organizations, making decisions about whether an asserted religious exemption is sincerely held. And I think we are going to see some of those cases.
And those are some of the very major cases right now with regard to free exercise of religion, these vaccinations. No.
Yeah, no, I wasn't aware. So you have actually like a religious governing body that says our religious belief doesn't prohibit X or prohibits X, and purports to bind its adherents to that.
So you've got a state hospital that has a religious exemption.
Yeah.
But some of it, so people have to apply for the exemption, and some of those are turned down because someone makes the determination that it's either not religious or it's not sincerely held belief. So there's looking at actually that assertion of belief in a way that I think is different from what we've seen.
Right. And I think that at least in some contexts, the big difference there is going to be, unless it's like a state-run hospital or something like that, it's going to be a private company that's making that. And if a private company is, drawing religious accommodations one way or another, it's not subject to the free exercise clause. It's subject to Title VII of the employment discrimination laws that prohibit discrimination based on religion, or makes you engage in a reasonable accommodation of religious beliefs. And that's a much lower standard.
And which is why you see some states like New York, you're not allowing religious exemptions to vaccine mandates, right? So they duck the question, but the others are allowing it. So it's sort of percolating all over the country.
And of course, there are religious bodies. One of them, the Church of Jesus Christ Scientists, that prohibit medical treatment. And oftentimes there are cases that arise. What do you do with their children when their children are ill and the parents are saying, well, we're Christian Scientists, we don't want medical treatment? Well, the courts have been very delicate in how to handle that. They perhaps might appoint the legal guardian for the child who then gets the blood transfusion or other medical care. Yeah, those are tough cases. A lot of these cases are really tough because they really involve, Noel's been talking about balancing, and Elliot's talking about, all these very important interests. There's a conflict. There is a conflict of very important interest. And as I tell my class all the time, if you just want to see one side of it, you're just being blind. You may favor one side over another. When you do your balancing, you may balance it differently than I do, or Elliot, or Noel. But the fact that these are tough cases, don't think that these are easy. These are really tough cases. And people who don't take rights on both sides seriously, they're the only ones that think these are easy cases. Go ahead.
So talking about the cake trap case, from an equal protection standpoint, I know we've talked a lot about the strict scrutiny test, but how does the intermediate scrutiny test play in? Because I know in common law, we were talking about how gender is under the intermediate scrutiny rather than strict scrutiny.
So, and Elliot might be interested in this too. Elliot, the question is, because you might not have been able to hear it, how does the equal protection clause play into a case like the Masterpiece Cake Shop case? The baker himself is not a state actor. So the baker himself is not going to be subject to the equal protection clause at all. I guess there might be a question as to whether the state would violate the equal protection clause if it didn't affirmatively prohibit discrimination based on sexual orientation or some other aspect of this law. But I think in general, the state can't affirmatively discriminate, but if a state repealed its anti-discrimination laws, I don't know that that would necessarily violate the 14th Amendment, as long as the state itself wasn't taking the further step of affirmatively discriminating against individuals based on protected category.
And of course, the intermediate scrutiny test is just the result of, you can't get 5 justices on one side or the other side. And with regard to LGBTQ rights, the court isn't anywhere. It's not strict, it's not routine, it's not intermediate. Who knows what it is, right? There was a question up here. No. Do we have any other questions? Yes, go ahead, thank you.
I was wondering if the panelists could share your views on the upcoming Kennedy versus Bremerton School District case, the one involving the Texas high school coach. Or no, I think it's Washington State high school coach. And why the Supreme Court has decided to hear this, and what is the expected outcome?
Elliot, you want to go first?
Sure. It's a very important case that in fact is supposed to be argued before the end of the month. Frankly, in my view, it's all going to depend upon how the facts are interpreted. The court took the case premised on the coach's version of the facts, which is radically different from the school districts and frankly, in my view, from reality. He's claiming, oh, all I'm asking for is the right with a group of friends to go right near the 50-yard line after a football game is over and have a quiet little private prayer. Well, the facts totally contradict that, as exemplified by video and other evidence, and relate to a much different situation where the coach for a number of years has been trying to, frankly, promote, if not coerce, players to join him in various forms of pre-game, in this instance, post-game prayer, and in which many others join as well. And I think those are two very, very different situations. I think there's no question the court would uphold the right of a coach or somebody else to have a private, quiet prayer once their duties as a government official were done. But if the court interprets it that way, he'll win. But if the court interprets it more the way reality seems to suggest, then the question is, will the court use this case as a way to significantly decrease the protections of the Establishment Clause and argue that as long as the government isn't making the coach do this, if he wants to get up and do it, even though he's still the football coach and in his capacity as a governmental official, we're not going to stop it from happening. So I don't know which way the case will come out, but I do think how the facts are perceived by the majority of the court will be critical.
I don't make a lot of predictions on how the Supreme Court is going to decide cases, but I got to imagine they didn't take this case to rule against the coach here. So I suspect that the coach is going to win, probably because they understand the facts, as Elliot explained was the coach's point of view. I actually filed a brief, an amicus brief in that case in conjunction with the Pepperdine Law School Religious Liberty Law Clinic that I participate in. And we articulated a principle that would have the court go a little bit further when it comes to Establishment Clause jurisprudence. Our argument is that the line in Establishment Clause jurisprudence is not a government actor engaging in religious speech, but is a government actor coercing others to engage in religious conduct. I mean, Elliot made the case that maybe that test could even be satisfied here on a particular set of facts. But in our view, that's where the standard is drawn. And you have the government engaging in religious speech all the time, including, prayers in Congress on our money. To me, the line in the Establishment Clause is whether you're trying to coerce others to engage in religious conduct. Traditionally, it was done through, if you look back to the founding, when there were lots of establishments of religion across the country, you had states imposing taxes to support the church, states imposing punishment if you didn't attend a particular religious service. That, to me, has always been the core of what the Establishment Clause is about. And a simple religious statement by a government official untethered to that kind of coercion, at least in my view, doesn't run afoul of the establishment.
Let me add one other very small comment. I think that could very well be a critical issue in this case. More than 10 years ago, the court squarely rejected, due in large measure to David Souter, the coercion test, and instead adopted what one might call a promotion test. Is this government official promoting religion? In the context of the football coach, that's a tough line to draw. If you're one of the players on that football team and the coach says, hey, let's all go out and pray right after the game at the 50-yard line, and you want to start next week, don't you think you feel a little coercion in that instance?
You might, and that's, to me, that's the question. That's the question that ought to be asked.
Well, in any event, but I mean, the argument has always been there has to be legal coercion, and there wouldn't be legal coercion in that case. But I think the effect on the high school football players would clearly be coercive.
Non-establishment clause was raised. We're at the end of this program, but I want to provoke you into having another one of these on the non-establishment. And my question is whether the current Supreme Court's free exercise jurisprudence is by and large saying that the non-establishment clause is unconstitutional, because they don't seem to be allowing much separation of church and state. But I think those are great issues. And Justice Thomas, I don't know why I keep looking at you when I say Justice Thomas, but he's got some interesting things. I mean, he says the non-establishment clause should not even apply to the states, and actually there's some merit to that. But in any event, I'll leave it with that, and you guys have to have another one of these. All right, thank you so much.
All right, sounds like a plan. Thank you, everyone, for coming. Concludes today's program. Again, I want to thank you all for coming. We will be hosting a reception down in the East Foyer. Hopefully you all can join us. Those of you on Zoom land who I know are throughout the building, you're of course by all means welcome to come and join us down in the East Foyer. Again, thank you, Professor Bonventre. Thank you, Noel. Thank you, Elliot, for joining us. And I guess with that, we shall adjourn. Thank you.